I'd like to begin by paying my respects to the Gadigal people of the Eora Nation, whose traditional land I am here on in inner Western Sydney. I'd also like to pay my respects to elders past and present and extend that respect to all Indigenous peoples listening onto the Zoom today. I'm really excited about this panel. I think Yuri Mantilla, Professor Mantilla from Liberty University School of Law will talk a little bit more about the reason why we're here today, and so will Leonardo Crippa, the senior attorney at the Indian Law Resource Centre. But I'm really excited about this panel. We're going to hear from three fantastic speakers about the Inter-American Court of Human Rights jurisprudence when it comes to Indigenous people's rights to land. We're going to begin with Professor Sorely Figueroa from the Pontificia Universidad in Quito in Ecuador. And so Sorely is going to speak in Spanish in her presentation. And then we're going to hear from, Sorely will speak for about 10-15 minutes. We'll then hear from Leonardo Crippa, as I said, the senior attorney at the Indian Law Resource Centre, for another 10-15 minutes. Sorely is going to talk about, provide an overview of the law in this area, and Leo is going to discuss the outline of the case and the role of the Indian Law Resource Centre at this specific moment. And Professor Yuri Mantilla will then discuss the Amicus, or the Amici, and offer his thoughts on where the court might go, I imagine. We've then got about 10-15 minutes, depending on how much time left. We're going to open up for questions and then final thoughts. So we only have 1 hour, so I'm going to finish now so we can get straight away. But we'll begin with Professor Sorely Figueroa. Thank you.
Okay. Good afternoon. I am Sorely Figueroa. I am from Venezuela. Thank you very much for your invitation. It is an honor for me to participate in this event. Thank you very much. Voy a hablar en español, mi lengua madre, el idioma en el que me siento cómoda tratando este tipo de temas sobre reconocimiento de derechos indígenas. Tengo muchos años estudiándolo, estos temas, y para mí es un honor estar sentada aquí al lado del maestro Yuri, del maestro Leonardo, y muchas gracias, Harry, Chia, sorry, okay, thank you very much. Muchas gracias por la invitación y bueno, a la Sociedad Americana de Derecho Internacional por brindarme esta oportunidad. Les voy a presentar unas diapositivas, una presentación en PowerPoint muy breve. Y bueno, si tienen alguna duda en el tiempo que tenemos para preguntas, estoy a la orden. Siempre que sus preguntas sean en español, puedo responder, a menos que haya un traductor o un intérprete entre nosotros. Okay, muchas gracias. Voy a comenzar. Voy a compartir la diapositiva. A mí me corresponde hablarles un poco sobre la libre determinación de los pueblos indígenas en el marco del sistema interamericano de derechos humanos. Les voy a dar unas ideas generales sobre este tema. En la actualidad, hoy por hoy, siglo XXI, año 2022, podemos afirmar que existe un consenso sobre lo que podemos entender sobre libre determinación de los pueblos indígenas. Por ejemplo, en la Declaración de las Naciones Unidas sobre los Derechos de los Pueblos Indígenas de 2007 y la Declaración Americana sobre los Derechos de los Pueblos Indígenas de 2016, ambos coinciden en su artículo 3, es el mismo texto, y establece que los pueblos indígenas tienen derecho a la libre determinación, entendiendo esto como el derecho que tienen a determinar libremente su condición política, perseguir libremente su desarrollo económico, social y cultural. El artículo 4 de la Declaración de las Naciones Unidas sobre el reconocimiento de los derechos de los pueblos indígenas de 2007, en el artículo 4 nos profundiza un poco más qué podemos entender por la libre determinación. Y es el derecho que tienen estos pueblos a su autonomía, al autogobierno, para tratar sus cuestiones, sus asuntos internos locales y disponer de medios para financiar sus funciones autónomas. Ya el convenio 169 de la OIT, de la Organización Internacional del Trabajo, de 1989, nos daba criterios sobre qué podíamos entender sobre la libre determinación de los pueblos. Este convenio tiene 24 ratificaciones y, por ejemplo, a lo largo del texto vemos criterios sobre reconocimiento de la libre determinación asociados a otros derechos. Por ejemplo, el artículo 7.1 de este convenio establece que los pueblos indígenas tienen derecho a decidir sus propias prioridades en lo relacionado al proceso de desarrollo, en la medida que esto afecte sus vidas, creencias, instituciones, bienestar espiritual y a las tierras que ocupan o utilizan de alguna manera, y especialmente a controlar, en la medida de lo posible, su propio desarrollo económico, social y cultural. Visto así, pareciera que todo este consenso fue fácil llegar a estos avances. Todavía falta mucho, pero tenemos que reconocer que hay cierto consenso, cierto acuerdo, vemos los tratados internacionales, pero no ha sido un proceso fácil y todavía nos falta mucho camino por recorrer. Tomen en cuenta que en el contexto latinoamericano estamos hablando nada más y nada menos de 33 estados, desde el norte de México a la Patagonia Argentina. Estos estados, algunos de estos estados tienen un sistema unitario, tienen un solo sistema, una sola administración, como es el caso de Colombia, por ejemplo. Otros son un sistema federal o son un estado federal, como es el caso, por ejemplo, de México y es el caso de Brasil. Entonces, imagínense, ese contexto ya hace un poco complicado el estudio del tema, en la teoría y en la práctica. Estamos hablando de 500, nada más y nada menos de 522 pueblos indígenas a lo largo de Latinoamérica. Y estamos hablando de 420 lenguas indígenas distintas. Entonces ya por allí podemos simplemente ver lo que denota la complejidad del tema. Claro, como les venía diciendo, estamos hablando de cierto consenso en el ámbito internacional. Tenemos que recordar que la primera constitución, la primera carta magna que reconoce de la forma amplia que entendemos ahora los derechos de los pueblos indígenas fue la Constitución de Brasil en 1988. Eso le siguió la adopción del convenio 169 de la OIT en 1989 y después progresivamente las constituciones fueron ratificando el convenio 169 y las constituciones de los países latinoamericanos fueron adoptando o fueron promulgando nuevas constituciones que reconocían estos derechos. Por ejemplo, la Constitución de Colombia de 1991, la de Perú de 1993 y la de Venezuela en 1999 y la más, vamos a decir, moderna y desarrollada en estos tiempos de vanguardia, la Constitución de Bolivia de 2009, que incluso reconoce el Estado plurinacional de Bolivia. Ahora bien, enumerando algunos del número de pueblos indígenas que existen a lo largo de Latinoamérica, algunos, podemos decir que Brasil cuenta con 241 pueblos indígenas. Es el país con más diversidad de pueblos indígenas. Colombia tiene 83, México tiene 67, Perú tiene 43, Bolivia tiene 36, Venezuela tiene 34, Guatemala tiene 22 y Ecuador tiene 14. Nacionalidades y pueblos indígenas. Imagínense ustedes, ¿no? Y estos son algunos, solo algunos. Entonces, a lo largo del siglo XX, la gran discusión o el debate que existía en torno al reconocimiento del derecho de los pueblos indígenas era, se los digo de una forma esquematizada, ¿verdad? ¿Son poblaciones o eran pueblos? ¿Eran poblaciones o pueblos? Se superó, son pueblos. Estamos hablando de pueblos. Estamos hablando de naciones. Estamos hablando de naciones, claro que sí. Entonces, si se reconoce el derecho a la propiedad colectiva de las tierras de estos pueblos, de estas naciones, si se reconoce el pluralismo jurídico, los diversos usos y costumbres, los diversos sistemas jurídicos de cada uno de estos pueblos indígenas que reconocen las constituciones latinoamericanas y la normativa internacional, y se reconoce el derecho a la libre determinación, entonces el gran temor, el fantasma que existía en torno al reconocimiento de los derechos de los pueblos indígenas, especialmente de la libre determinación, era la sucesión de Estado. precisamente. ¿Hasta qué punto los movimientos indígenas iban a establecer procesos independentistas dentro de los diversos estados de Latinoamérica? Se podrán imaginar, estamos hablando de 522 pueblos. Recordemos el proceso zapatista en Chiapas, en México, sumamente complejo, que ya está bastante superado, pero ese era el gran temor de los estados. Entonces, ¿qué sucede? El temor de la sucesión de estados hoy, en el año 2022, ya está superado. Ya los conceptos, el mismo convenio 169 de la OIT, en el artículo 1, lo despejaba. Reconocimientos de pueblo, no en el sentido del derecho internacional. Y vemos la Declaración Americana sobre los Derechos de Pueblos Indígenas del 2016. Señores, esta declaración duró 17 años en discusión por la complejidad del reconocimiento de estos derechos, entre otros el de la libre determinación de los pueblos. Sin embargo, ya vemos que el artículo 4 lo deja claro. El reconocimiento de estos derechos no da potestad a los pueblos, a los grupos indígenas, a participar en actividades o actos contrarios a la Carta de Organización de los Estados Unidos, de los Estados Americanos, perdón, a la Carta de la OEA y a la Carta de la ONU. No se puede ir contra estas cartas internacionales, OEA, ONU. Y tampoco, evidentemente, se puede entender estos derechos como una autorización que alienta acciones encaminadas a quebrantar o menoscabar total o parcialmente la integridad territorial o la unidad política de los estados soberanos e independientes. Quedó claro el tema de la sucesión de estados, quedó superado. Sin embargo, evidentemente, ha sido un proceso largo, con diferentes discusiones, diferentes debates. La sucesión de estado ya quedó superada. Pero estamos en un punto de avance, y eso ha sido gracias, entre otros factores determinantes, al papel de la Comisión Interamericana de Derechos Humanos y la Corte Interamericana de Derechos Humanos. Sin la labor, sin la jurisprudencia interamericana, no estaríamos en el punto que estamos ahora. Insisto, de avance. Sí, ciertamente tenemos mucho que alcanzar y lo vamos a ver a continuación. Pero ha habido un avance, ya tenemos criterios jurisprudenciales para defender los derechos de estos pueblos. ¿Cuál es vamos a decir, el centro del debate actualmente? Desde mi perspectiva se las voy a explicar. Tomen en cuenta lo siguiente. En las tierras indígenas están los mayores yacimientos de recursos naturales de los estados latinoamericanos. Actualmente verificamos gran parte de la controversia en este punto. Estamos hablando de renta económica de los estados. Estamos hablando de ingresos, recursos económicos e ingresos económicos, que están precisamente a lo largo de las tierras indígenas. Entonces, para darles un ejemplo, solo un ejemplo, las exportaciones de carbón en Colombia para el año 2021 aumentaron en 35.7%, llegando a 5.652 millones de dólares. Aquí les coloco una imagen de la mina de Cerrejón en la Guajira colombiana, precisamente en los territorios del pueblo indígena guayú. Entonces, en contraposición, les pongo una imagen de los niños desnutridos del pueblo indígena guayú y una mujer tratando de buscar agua. Vean las condiciones en que está ese arroyo de agua, porque los ríos han sido desviados. En la Guajira colombiana, donde está el pueblo de guayú, debido a la extracción de carbón en la mina Cerrejón. Hay sequías, hay enfermedades, y sobre esto ya se ha pronunciado inclusive la Comisión Interamericana de Derechos Humanos, que ha establecido medidas cautelares, y especialmente en el caso de la desnutrición de los niños indígenas. Ahora bien, les voy a enumerar algunos de los casos que sustentan esta problemática. Algunos, los dos primeros ya han sido resueltos por la Corte Interamericana de Derechos Humanos, lo ha conocido, ha dictado sentencia, y otros pocos más que les voy a enumerar de forma muy breve. La primera, la concesión de explotación de madera que otorgó Nicaragua a la empresa Solcarza en la comunidad Magdalena Agua, un clásico. La Corte Interamericana de Derechos Humanos se pronunció el 31 de agosto de 2001 sobre este tema y nos dio los primeros criterios sobre qué debemos entender por propiedad colectiva de estas tierras, correlacionados a otros derechos. Los que nos dedicamos al estudio de este tema, por obligación, tenemos que acudir a estas sentencias de la Corte Interamericana para entender la interpretación y aplicarla en la práctica, ¿no? Obviamente en el sistema interamericano. La segunda, otro clásico, vamos a llamarlo así, Sarayacus versus Ecuador. La concesión de extracción de petróleo que dio Ecuador en la empresa petrolera CGC en las tierras sagradas del pueblo indígena Sarayaco. La Corte Interamericana se pronunció en 2012, reiterando criterios y dándonos muchos más criterios para entender la libre determinación de los pueblos indígenas y cómo entender la propiedad colectiva de las tierras indígenas desde sus recursos naturales. Señores, yo estuve mucho tiempo trabajando en Ecuador, tengo que corregir, yo actualmente no soy profesora de la Universidad Católica del Ecuador, con mucho cariño trabajé allí, tuve que regresar a Venezuela, actualmente yo me encuentro en Venezuela. Yo estudié este caso junto al doctor Mario Melo, es una referencia sobre estos temas, y les puedo decir y les puedo afirmar que la sentencia Sarayacus todavía no se ha cumplido. Escasamente se ha cumplido. Es muy interesante. Luego tenemos el caso de los pueblos indígenas Tagaeri y Taromenane versus Ecuador. Este es un caso que se está conociendo actualmente en la Corte Interamericana. Ayer se dio la primera audiencia pública, 23 de abril, en Brasil, donde se están llevando las audiencias públicas de la Corte Interamericana en esta sesión. Esto es un pueblo indígena en cuyo territorio se han dado, o Ecuador ha dado concesiones de recursos naturales, inclusive se han dado muertes de integrantes de estos pueblos indígenas en 2003, en 2006, en 2013, e inclusive se ha demostrado la violación a la integridad de niñas de este pueblo indígena. Estamos esperando todos los académicos que nos dedicamos al estudio de estos temas, esta sentencia, que va a ser muy interesante porque nos va a seguir ampliando los criterios sobre la libre determinación y cómo entender la propiedad colectiva de las tierras indígenas, evidentemente. Bueno, les vuelvo a hablar sobre el caso de la explotación de carbón de la mina de Cerrejón, de Colombia, dentro del territorio del pueblo indígena Guayú. Ya se los expliqué. Esta es la explotación de carbón más grande a cielo abierto del planeta. Ha traído contaminación, desplazamiento del pueblo Guayú, desvío de arroyos, sequía, muerte de desnutrición de niños. Y les reitero que la Comisión Interamericana ya se ha pronunciado, inclusive dictó medidas cautelares. Y por último, dentro de los casos que estoy enumerando, el que nos tiene aquí reunidos hoy, aquí sentados el día de hoy, que son las concesiones de proyectos mineros que ha otorgado Guatemala dentro del territorio de la comunidad maya en Agua Caliente, y del cual mis compañeros, el doctor Yuri y el doctor Leo, van a profundizar. Ahora bien, los elementos, porque en este punto tenemos que entender que existen elementos para entender el derecho a la libre determinación dentro de los instrumentos y la jurisprudencia del sistema interamericano. El 28 de diciembre de 2021, la Comisión Interamericana dictó un informe que nos enumera estos elementos para entender, y claro, lo desarrolla, yo les estoy haciendo un esquema, un resumen, cómo entender esta libre determinación. Primero, autoidentificación y reconocimiento de los pueblos indígenas y tribales. Segundo, identidad cultural y no discriminación. Tercero, propiedad colectiva de tierras, territorios y recursos naturales. Porque siempre me pregunto, ¿de quién será el carbón que se extrae de Cerrejón? Luego, derechos políticos y de participación, consulta y consentimiento libre, previo e informado, derechos económicos, sociales, culturales y ambientales. Estos son los criterios. Finalmente, ya para terminar, les voy a hablar de dos sentencias que realmente es lo que me tiene aquí. Me invitaron por mis conocimientos del tema, especialmente en relación al sistema jurídico colombiano, ecuatoriano, venezolano. y lo voy a hacer a manera de derecho comparado. Deben entender que la Constitución colombiana de 1991 es sumamente interesante en cuanto al reconocimiento de los derechos indígenas. Y aún más, la interpretación que ha dado la Corte Constitucional de Colombia de la Constitución, la interpretación que ha dado sobre los derechos constitucionales es riquísima. Desde el año 1996 estamos estudiando sentencia tras sentencia que reconocen todos estos derechos y especialmente de la libre determinación. Esta sentencia T-444-19 de 26 de septiembre de 2019 reitera que se reconoce el derecho a la autodeterminación, entiéndase libre determinación de los pueblos, que implica el derecho que tienen estos pueblos a tomar decisiones relativas a su desarrollo económico, social y cultural y a disponer de sus riquezas y recursos naturales en sus territorios, conforme a sus usos y costumbres, dentro de los límites constitucionales. Luego, la sentencia, esta es una de las últimas que ha dictado la Corte Constitucional en relación a este tema, y es entender o reitera la jurisprudencia de la Corte Constitucional de Colombia que el derecho a la libre determinación de estos pueblos, conforme a la Constitución del 91, implica la autonomía o autodeterminación de los pueblos, entendidos como el derecho que les asiste a decidir sobre sus asuntos culturales, espirituales, políticos y jurídicos, de acuerdo con sus usos y costumbres.
Sorry, I'm very sorry.
Estoy terminando.
Okay, thank you. If you conclude now, sorry, thank you.
Sorry. No, entiendo, I understand. Para terminar brevemente, para noviembre de 2021, un estudio certificado por la Conferencia de las Partes de la Convención Marco de las Naciones Unidas sobre el cambio climático de 1992 identificó nada más y nada menos que 958 millones de hectáreas de territorios indígenas. Entonces, es necesaria la explotación sostenible de los recursos naturales por parte de los estados de América Latina. Yo entiendo, porque ya tanto tiempo estudiando este tema, ¿verdad? Casi 20 años. Yo no puedo estar en un mundo de ilusión pensando que Colombia no va a extraer el carbón de un día para otro, por los ingresos y la renta que eso implica. Pero puede ser una explotación sostenible, respetando la libre determinación del pueblo guayú, respetando los derechos previstos en los tratados internacionales y en la Constitución colombiana y en la jurisprudencia de la Corte Constitucional. Esta libre determinación de los pueblos, reconocimiento a su autogobierno, a su autogestión, respeto al derecho de la propiedad colectiva de sus tierras, respeto al derecho de la consulta previa, respeto al sistema de regalías y compensación, es sumamente importante, porque con esto se garantizaría un desarrollo económico sustentable. Se podría mitigar los embates de la extracción de los recursos, el daño medioambiental, los efectos del cambio climático en estos territorios. ¿Por qué? Porque lo más importante es respetar, garantizar los derechos humanos de estos colectivos indígenas. Entiéndase, vida, salud, alimentación, educación, vivienda, identidad e integridad cultural. Thank you very much. Muchas gracias. Estoy a la orden para sus preguntas al final de la conferencia. Muchas gracias.
Thank you so much, Sarli. Sorry for jumping in a little bit there. I was trying to keep everyone on time, but thank you. And thanks. It was really great comprehensive overview of the area. And I think another example, I guess, of the benefits of a forum like ASL, where we can get people from all over the world with great expertise in these areas. So thank you so much. I might let now Leonardo Crippa from the Indian Law Resource Center present. Thank you.
First of all, I want to thank the ASO Rights of Indigenous Peoples Interest Group for that amazing Amicus Curiae brief that was filed in the case of the Agua Caliente community versus Guatemala. My name is Leonardo Crippa. I am a senior attorney at the Indian Law Resource Center, Washington, D.C. office, and the leading attorney in the case of the Agua Caliente community that I'm going to very briefly, no more than 10 minutes, refer to. Let me see if I can share the screen. Okay, let's get started. So I was asked to provide some information about the case and the role of the center. So I'm going to do this very quickly. Starting with the Agua Caliente community. The Agua Caliente community is a Maya Quechua community of about 66 family, roughly 370 members. It's a monolingual community. Only about 5 members of this community are bilingual. That is, only 5 of these members speak Spanish, apart from the native language Quechua. It's a very isolated community located in the municipality of Belestor, in the department of Izabal in Guatemala. Something important for you to know about this, the location of this community, is that it is part of a block of 16 lots that was identified by the state of Guatemala back in 1891 with the first survey that was made. During that survey work, the name of the community and the location was clearly identified and then ratified in 1929 by the Ministry of Foreign Relations Boundary Commission. These are very historical documents, very important, and it sort of reflects the historical location of this community in this part of Guatemala. I'll get back to this in a minute. This community make decisions through assemblies. They meet on a regular basis. There are currently 2 sort of decision-making institutions that I'm going also to refer to. It is important for you to know that there is one self-created institution called the Improvement Committee. That's basically the Comité Pro Mejoramiento. It's a sort of a committee created by the Maya communities in Guatemala to address issues relating to land, natural resources, issues of common interest for the entire community. It is not something imposed by any Guatemalan legislation or policy. It is something that the community itself created for the purpose of addressing these issues. On the other hand, there is the Community Development Council, and this is an entity created by municipal law in Guatemala. It is created for the purpose of handling all the relationship between an indigenous community or an agrarian community in Guatemala and the state of Guatemala, particularly the municipality, for everything relating to development, economic development in particular. So in this particular case, we have these 2 institutions. One is the self-created Improvement Committee, and then the state-imposed Community Development Council. The case was filed in domestic courts and afterwards with the commission and the court by the entity created by the community itself, which is represented by Rodrigo Tot. He is the president of that committee. He is an outstanding leader that won the Goldman Environmental Prize back in 2007. The community has about 50% of the members are children, and about 18% are elders. Let's move on. What's the center role? The centers, for those that don't know about who we are, the Indian Law Resource Center is a non-profit law and advocacy organization that was created in 1978. It was funded and is still directed by Native American attorneys in the US. It has 2 offices, one in Montana and the other one in Washington, DC. And we provide free legal advice to Indian nations and Alaska Native here in the US, and indigenous peoples and communities in Mexico, Central and South America. We sort of have a program of capacity building and then free legal advice and representation before domestic courts and international proceedings. The case of the Agua Caliente community is one of those cases that we have been handling since 2007. A big case that probably you are more familiar with is the Aguastigny case that was previously mentioned by the previous speaker. That's a case that we also handled representing the Aguastigny community in Nicaragua. Very briefly, the way the center works with communities is like a clear attorney-client relationship. We represent the community. We only take emblematic cases. We are very selective in terms of the cases that we decide to take. We don't work through intermediaries. That is, we don't work through a non-governmental organization. We actually work with the community itself, and together we build the legal strategy through different meetings. For this particular case, we worked very closely with Carlos Pop. He's a Maya Quechua attorney in Guatemala and was the leading attorney in all the litigation before Guatemalan courts. And in the litigation before the commission and the court, I was the leading attorney with Carlos Pop. Let's move on a little bit more quickly. Now, I'm going to provide you some of the sort of cross-cutting issues that you probably have a lot of interest in hearing about that came out in this case. In this particular case, there is a block of 16 lots. One of those lots is lot 9, and that's the lot being occupied by the Agua Caliente community since 1891. That particular lot, as you can see in this image, is in the middle of an overlap with a mining project area. And this is a very important fact of the case, because particularly in Guatemala, there is a lack of legislation recognizing indigenous peoples' collective land ownership. And as a result, indigenous peoples are only allowed to access land title through an agrarian land titling procedure that provides community with a title that recognizes co-ownership over the land instead of a collective ownership. For example, this particular community acquired a provisional title under that land titling procedure back in 1985, and as a result, that title recognizes co-ownership in favor of 64 peasants. They don't even recognize indigenous peoples there by law. Another big issue in this case is that there is no legislation in Guatemala that recognizes indigenous people's right to participate in decision-making relating to the development of natural resources or the sharing of benefits, even though there is an overlap with the mining project area and this community land has been explored and nickel has been identified in that land. This community was not able to participate neither in the mining permits procedure nor in the environmental impact assessment procedure. Let's move on a little bit more quickly. And this is going to be the last one. And after this, I'm going to provide you more sort of an outline of the case very quickly. In the map that you can see here in this slide is basically a slide that provides an overview of the 16 lots, particularly the Agua Caliente community, where you see number 251. That's basically the site of the mining project that overlaps with the Agua Caliente land. That site is going to be exploited in the coming for 15 years. It didn't start yet, the exploitation, but the exploration was done, and it was detected nickel in that part of the community land. In terms of procedures, as I said, neither the mining code nor the environmental law in Guatemala recognizes indigenous peoples any right to participate in the decision-making procedures. There is no legislation in Guatemala that regulates how indigenous peoples should be consulted regarding decisions that are going to affect their rights, nor any legislation that recognizes a free, prior, and informed consent of communities when a decision is going to be made that will affect their survival, such as, for example, mining on their lands. Another particularly interesting fact of this case is that based on the lack of legislation on these procedural rights, the executive branch of the government is starting to resort to state-imposed development community councils for the purpose of carrying out consultations with communities in detriment of the community's self-created institutions. And so there is a conflict there of institutions, and the government is starting to use those that are created by the law of Guatemala instead of those that are created by the customs and the traditions of the communities themselves, which clearly identifies their self-government and self-determination rights. Now, how am I doing with time, Larry? I'm a bit concerned about that.
So it's 11 minutes now, Leo.
Yeah, okay. Let me just spend 2 more minutes with some important detailed information. The overlap that exists between the mining project area and the community land is about 947 hectares of land, which equals 2,340 acres of land, so that you have an idea about the extension of the overlap. The community started the land titling procedure back in 1974 with a land claim under the agrarian land titling procedure. And in 1985, the land titling agency issued a provisional land title that acknowledged the community's co-ownership right to the land in favor of 64 peasants instead of the entire community. There is no collective land title that recognizes the community as a whole as a land right holder. In 1998, the land registry office was informed about a stolen page of the registry book that registered the 1985 provisional land title. And as a result, this particular agency asked the community itself to take legal actions to get the stolen pages replaced. The legal implications of having those pages stolen is that basically it prevents the state agency from issuing the final land title. In the meantime, in 2004 and 2006, another state agency issued permits to explore and exploit nickel in that part of Guatemala and in the land belonging to this particular community. So what this community did as a matter of legal remedies, it filed 3 lawsuits back in 2004 and 2007, asking the judicial branch of the government to order the replace of the stolen pages. The remedy was rejected, and as a result, back in 2009, and that's when we got engaged, we sued the land titling agency, because according to Guatemalan law, the land titling agency is mandated to take all actions to fulfill its mandate, which is provide land titles. In February 2011, the Constitutional Court of Guatemala issued the final decision in favor of the community and ordered the land titling agency to take all necessary actions to replace the stolen pages and issue the final land title. In May of 2018, we filed another lawsuit because of the non-compliance with the Constitutional Court 2011 decision. Basically, the community was never issued the final land title. The Constitutional Court of Guatemala again ruled in favor of the community back in 2019. And in the meantime, the mining company is still operating. There is no decision in the country yet stopping the mining company from exploiting the lands of this community. After this, the case was brought to the commission, and now it's before the court. And I will now let Dr. Yuli Mantilla to talk about the amazing Amicus Curiae brief that was presented by the interest group. Thank you.
Thank you so much, Leonardo. That was an excellent overview as well. And goes very neatly into Professor Mantilla's conversation. Thank you, Professor.
Well, thank you very much. So when you have a case like this, the question is, what can law professors from countries around the world, from Canada, New Zealand, United States, other countries, what can professors do? What can human rights lawyers do? What can students of international law universities in Europe do about this, right? It's the question is if this is in a specific case of indigenous peoples of Guatemala, what should be a global response? Because in a globalized world, things that are happening in one country, such as Guatemala, regarding indigenous people's rights, it has an influence for all indigenous communities around the world. So from that perspective, this group of scholars, human rights activists, professors, students decided to get together and to write this amicus brief to the Inter-American Court of Human Rights with the hope of helping the court understand these issues from a global justice perspective. So how do you do that? How do you help judges at the Inter-American Court of Human Rights to understand that this decision can become a theoretical and legal precedents, can influence decisions around the world? And what was our strategy to address these issues, taking into consideration general international law, comparative international law, taking into consideration law as a system that focuses on justice? How can we focus on a brief like this to highlight the fact that indigenous peoples are subjects of international law, to highlight the fact that indigenous peoples have an international legal personality? And so the first part of the brief focuses on general international law. Indigenous peoples have the right to self-determination consistent with international human rights law. As you know very well, this is reflected in Common Article 1 of the International Covenant on Civil and Political Rights, and also in the International Covenant on Economic, Social, and Cultural Rights, which, as you know, it says that all peoples have a right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And also based on this, we have analyzed regional instruments that also recognize the right to self-determination, including the African Charter of Human and People's Rights, cases such as the East Timor case at the International Court of Justice, where the International Court of Justice found the right to self-determination to be an erga omnes right, which, as you know, is binding on the international community at large. So in that context, we have analyzed all these international treaties, these international decisions by courts, but also more specifically, how does the right to self-determination applies to indigenous peoples? And so consistent with comment 12 of the Human Rights Committee, there is a very clear explanation that the right to self-determination is an inalienable rights of all peoples, including indigenous peoples as well. And so we also have looked, obviously, at the United Nations Declaration on the rights of indigenous peoples to make sense of how this right to self-determination applies more specifically to indigenous peoples. And we believe, and consistent with the amicus brief, that the United Nations the Declaration on the Rights of Indigenous Peoples is one of the most important instruments that highlights not only a United Nations declaration, but also reflects customary international law and some of the provisions of the United Nations Declaration on the Rights of Indigenous Peoples have been used by many courts around the world to make decisions regarding indigenous people's rights. So Article number 3 of the United Nations Declaration on the Rights of Indigenous Peoples, it says that indigenous peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. So in that context, to make sense of all these general norms of international law regarding indigenous people's rights, we also have looked specifically at the decisions of the Inter-American Court of Human Rights, which in cases such as the Saramacca people versus Suriname, in cases such as the Quechua indigenous peoples of Saracuyo versus Ecuador, the Inter-American Court of Human Rights has specifically used provisions of the United Nations Declaration on the Rights of Indigenous Peoples to address these important cases. So from that perspective, we can see how general international law, the general principles and norms of the rights of indigenous peoples it's applicable to a case like the one that we are analyzing today. But also in the United Nations system, we have found out that many international institutions, such as, for example, the one that is in charge of the implementation and monitoring of the Convention on the Elimination of All Forms of Racial Discrimination, have also addressed these issues regarding indigenous people's rights. And so in this specifically, we have comment number 21, in which the Human Rights Committee has cited many provisions of the United Nations Declaration on Indigenous Peoples' Rights regarding self-determination, and has recognized that this is very specifically applicable to indigenous people's rights to self-determination. So we have also the United Nations system and that has addressed issues regarding indigenous people's rights and specifically the right to self-determination. So what does it mean? Why all this is important? This is important because Guatemala is a state party to the International Covenant on Civil and Political Rights. The state of Guatemala is a party to the International Covenant of Economic, Social, and Cultural Rights. This means Guatemala has an obligation to fulfill, a legal obligation to fulfill the provisions of both covenants regarding the right to self-determination. And so Guatemala in this case, and also we need to remember that Guatemala signed the United Nations Declaration on the Rights of Indigenous Peoples, agree with the norms reflected in the United Nations Declaration on the Rights of Indigenous Peoples. So Guatemala has a legal obligation to fulfill all these principles in this case, in the Maya, Quechua, Agua, Caliente community case regarding the right to self-determination. But that's one aspect of our analysis. So we believe that international law, general international law applies to this case. But also we believe that within the American Convention of Human Rights, the Inter-American Court of Human Rights has an opportunity to make a proper interpretation of the American Convention of Human Rights and find that this American Convention recognizes the right to self-determination of indigenous peoples. As you know, the American Convention does not include specifically, and it does not have a provision on self-determination. However, consistent with principles of legal interpretation, such as the pro homine interpretation principle, we believe that the Inter-American Court of Human Rights has an opportunity to expand the interpretation of the American Convention and to recognize the right to self-determination, because at the end of the day, this is about results. It's about protecting the human dignity, the human rights of indigenous communities. So it is important that the court can make a proper interpretation of the American Convention of Human Rights. And so in order to sustain this view, we have used different strategies. We have different strategies of interpretation, such as focusing on Article 26 of the American Convention. I think I have very few minutes left, so I'm going to go very fast now. So Article 26 of the American Convention contains the rights to self-determination. We have made an analysis of the importance of implementing economic and cultural rights. And we have analyzed Article 26 of the American Convention. And analyzing this, we have argued, we have sustained the case that the Inter-American Court of Human Rights previously has also have an expanded view of interpretation of this kind of rights in other cases regarding different aspects of the law. And so it's not the first time that the Inter-American Court of Human Rights could use international corpus juris to apply to the interpretation of social and economic rights, in this case of indigenous peoples. So we propose that in this case, there is a very important normative interpretation regarding social and economic development of indigenous people's rights, in which the right to self-determination should become a fundamental tool to ensure the implementation of social and economic rights of Article 26 of the American Convention of Human Rights. In other words, you cannot implement social and economic rights of indigenous people's rights without recognizing the right to self-determination. So it is important for the Inter-American Court to consider an integrative economic development perspective that recognizes the social and economic dimension of the indigenous Maya, Quechua, Agua Caliente community, which is related, obviously, with the right to self-determination. And then, because of time, I am just going to just highlight a very few points of the brief next. We have also argued, based on Article 1.1 of the American Convention regarding the right to self-determination, and we have focused on the fact that it is essential to use this Article 1.1 regarding the obligation of states to accommodate cultural differences and promote the principle of substantive equality of indigenous peoples. And to do this, again, it's important to recognize the right to self-determination as an instrument to do this. And then Article 3 of the American Convention contains the right to self-determination. Article 3 of the Convention says that every person has the right to recognition as a person before the law. How is the Inter-American Court of Human Rights going to recognize the legal personality of indigenous communities? How? Well, it has to be recognized in the context that, as part of this legal personality, the right to self-determination provides the framework to precisely recognize this legal personality, the collective rights of indigenous communities, the right not only to property, but also to self-determination, including access to natural resources. So these also, and if you want to understand this better, I recommend you to read the brief. It's really interesting. It's very well done. And then again, in Article, we focus on Article 21.1 of the American Convention, in which we make the case again for an expanded understanding of the right to property. We believe that it is important to recognize the collective right to property of indigenous communities. However, we also believe that the right to self-determination is the foundation for that right of collective properties. Collective property is not enough. International law demands that the right to self-determination should be recognized. So all this is the second part of the analysis of the brief. But then there is a very important part of comparative law, in which we have focused on Canadian law, in the law of Canada, which is a fascinating source regarding indigenous people's rights, which, by the way, the Inter-American Court of Human Rights has in the past, in previous decisions, they have used Canadian law to inform them, to highlight some of their decisions, not because it's binding law, but because it's part of this global understanding of the development of indigenous people's rights. And in this, regarding the law of Canada, I will just very briefly focus on three main aspects. Here, the law of Canada, the decisions of the Supreme Court of Canada, can provide a very interesting strategy to address issues like the one that the Inter-American Court of Human Rights is addressing now. One, in the Supreme Court of Canada, in one of the last cases that they have decided, and this is the case of Tilsi-Cotin case, where the Supreme Court of Canada expanded Canadian law on indigenous people's rights. There are four main aspects that the Inter-American Court of Human Rights can use as inspiration. Obviously, this is not binding law for them. Number one, the doctrine of terra nullius never apply in Canada. Number two, the source of indigenous title is the preexistence of indigenous societies.
Yuri, I apologize, yeah. Yuri, we're going to have to wrap up really soon because the session will finish actually in 2 minutes.
All right, thank you. And so great analysis of that of the Supreme Court of Canada. And finally, the Supreme Court of Canada focuses on reconciliation and negotiation between indigenous community, negotiations in good faith between indigenous communities and the government of Canada to resolve this type of cases. And finally, we have also focused on the African human rights system to highlight the importance of, of taking into consideration different systems of law. So this, in synthesis, this is not only a case of Canada. We are all united on this. We all believe in the right to self-determination of the Agua Caliente community, the Quechua community in Guatemala, and that's why we believe that the laws of Canada, the African system of human rights have norms that reflect objective global justice, that reflects fundamental principles, including the right to self-determination of indigenous communities. So to finalize, we just ask and encourage the judges and the Inter-American Court of Human Rights to understand that this decision is about the recognition of the international legal personality of the Maya people, Quechua people of Guatemala, and this is, whatever you do is going to have an influence around the world. You will be praised or you will be heavily criticized. And we are watching, as legal scholars, and we really believe that in the 21st century historical context, it is essential to mainstream indigenous people's rights and indigenous perspectives as one main component in the study of international law. Thank you.
Brilliant. I just want to thank all of our speakers for fantastic presentations today, and of course to ASIL as well for the opportunity to have this venue, to have this really interesting discussion. I apologize to our participants. We don't really have time for questions as we're over time now, but I thought it might perhaps be interesting to end if I could quickly ask Leo when we might expect a decision in this case. I think that'd be of interest to all of our participants.
During the pandemic times, the court has taken about 7 to 11 months to issue the final decision. In this particular case, apart from the hearing, there was a private hearing to hear the testimony of the head of the Community Development Council, the state-imposed institution in the community. And so there were additional procedural steps that were taken by the court in order to have a better clarity on the issues at stake. So we don't expect a decision to be made by the end of this year. We hopefully will see a decision by spring of next year.
The spring of next year. Well, we'll be on the lookout for that. And if anybody does have any questions for our panelists that are attending today, please feel free to reach out to myself or to Harry, and we can get those questions over to the panelists, and we will of course keep you posted on what comes of this decision. So again, thank you very much again to our fantastic panelists today. Much appreciated.
Thank you, everyone.
Thank you. Thank you. Bye.